Hi, this is Helen Thomas again. We're going to continue with CDFM Module 3, Competency 1, which is Fiscal Law. We're going to pick up on page 3.1.29. So now we're going to look on the Anti-deficiency Act that relates to the amount of the appropriations. So we talked about purpose in the past, we talked about time, and now we're going to look at amount because we mentioned that there are 31 U.S. Code 1341, 1342, and 1517 that is discussed under 31 U.S. Code for Anti-deficiency Act for amount. So if you look on the bottom of those three bullets on page 29, it gives you the quick version. 31 U.S. Code 1341, obligating expending in advance or in excess of the appropriations. So based on whatever appropriation was approved for the, let's say, Department of Defense, if we obligate more, we spend more than what was received in the appropriation, then that's the 31 U.S. Code 1341. And that should more apply to Office of Management and Budget, because when we get the appropriation, that appropriation is then subdivided by Office of Management and Budget, OMB. So in order to expend or obligate in excess of the appropriation, that then tells me that's something that OMB, a violation that OMB can have in this case. 1342, 31 U.S. Code 1342 talks about voluntary services, whether we can accept voluntary services for jobs that are conducted by DA civilian. For an example, if a spouse wants to volunteer, they want to learn financial management, or be a financial manager. So can they just come into the office and sit with one of us to learn the job? Well, the clear answer to that is no. So, but of course, there are always exceptions for other instances. But as we know, you can't just have someone come in and volunteer so that they can learn the experience and then go apply for the job. It doesn't work that way. So the last bullet says 31 U.S. Code 1517. That talks about obligating or spending more than the apportionment report. So if you remember when we did the flow of funds, I said that OMB appropriates the money. Then actually Congress appropriates the money. OMB apportions the money to the agencies, and the agencies like Department of Defense give the rest of us allotment. So if it's referencing here, obligating or expending in excess of apportionment, well, only the DOD gets apportionment, or if they reapportion it. So we know that 31 U.S. Code, clear-cut 1517, will apply to the agencies. So you kind of have to look at that. 1342 can apply to us because we may want to or try to have volunteers work in our facilities, but we need to know what the laws are associated with amount. And so in depth, they talk a little bit more about 1341, which is that obligating more than what was apportioned. It's listed there again. And on page 31, you need to know the 6 forms of budget authority. And as you know, in order for us to expend or to obligate funds, we have to have the budget authority to do so. So in one of those documents, we receive our budget authority. So if it's an appropriations act, you get budget authority from there. Now you can put these in alphabetical order, which is A, B, C, L, M, and O, to help you to remember. So A, appropriation; B, borrowing authority; C, contract authority. So we have authority to enter into contracts. L, loan and loan guarantees; M, monetary credits; and O, offsetting receipt. So forms of budget authority: A, B, C, L, M, O. And they just have to know what each one stands for. So at the bottom of 31, it gives you the definitions. But make sure you know the 6 types of budget authority. As we mentioned, starting on page 32, it talks about the limitations that we receive on these funding. Sometimes they come to us already earmarked. An earmark meaning it's a for specific purpose. So we either can have ceilings, which means you cannot spend no more than this amount. Floors, meaning you can spend no less. So those are laws that Congress sent. Or fence. Fence funds, meaning you can only use those funding for whatever it states in that appropriation authority. So that's what earmarking is on 32. Those are our limitations. 33, page 33 talks about the 31 U.S. Code 1342, which I talked about voluntary services. And as you can see, as mentioned, voluntary services, meaning it for the following interpretations may be made. If the compensation for a position is fixed by law, then an appointee may not agree to serve without compensation. So if it's a position that normally you will hire someone to do the job, we cannot accept someone to come in for no pay and just volunteer to get experience. The second bullet says, if the level of compensation is discretionary, meaning there's some pay you can get for that job, and the compensation can be set to zero, meaning in the description of the job, it also says you can work there for zero pay, then an appointment without compensation is permissible. Then I can have someone to volunteer. If you notice, the and the then are in capital letters. So both of those things, compensation is discretionary and that job can be set at zero. Third bullet on page 3.1.33. A service offered clearly and distinctly as gratuitous with a proper record made of that fact does not violate the statute against acceptance of voluntary services. And the bottom line, some examples of statutory, meaning those are activities or agencies that have already been vetted and approved to have volunteers, such as the Red Cross, the candy stripers that work at the hospital to volunteer to help out at the hospital, museum volunteers, people that want to work in the museum, but they don't need to get paid. So those are specific statutory authority that has already been granted to complete those volunteer missions. So we mentioned again on page 34, whenever you hear the word apportionment, just say OMB apportions funding to the agencies. So OMB apportions to the DOD. So let's see. It tells us on the 31 U.S. Code 1517, which states, and remember, that's how you have to tie it in, an officer employee, you can't spend no more than you are apportioned or reapportioned. So remember that on page 34. And on 35, there's another funding flow. Remember how things flow. Congress appropriate, give us the appropriation law. OMB apportionment, he apportions money to the DOD. The DOD and the other agencies issues allotments. And then at our level, we commit, obligate, and outlay. So outlay is the same thing as a disbursement. That's when the funding leaves the Treasury. So when you follow it from cradle to grave, from the time when the appropriation law was put into place till you actually spend the money, pay the bill, the outlay is the definition. So you notice they didn't use the word disbursement. So you need to know what an outlay is. Same thing though. All right. Page 3.1.36 talks about augmentation. Now, it also gives you the 31 U.S. Code associated with that. You can review those, but I haven't had anyone that said they had to know the augmentation laws, so I wouldn't spend a whole lot of time on it. Page 3.1.37. This is something that we all should be familiar with as far as ethics and fiscal law. Yes, it states the gifts to the United States can be accepted. The gifts may be real property or personal property. Second one, gifts to an agency. An agency may accept a gift given in the name of the United States. But if a gift is given in the name of an agency, the agency must deposit the gift to the Treasury. So let's say you have someone who passed away and they want to leave some money for your organization. Well, you cannot accept the funding as, oh, we got additional money for our organization or MWR funds. You have to send that money to the Treasury. And the idea is that Congress doesn't want people getting funding elsewhere and then you're increasing your appropriation spending based on what they were approved and what they expected you to have. The bottom of page 3.1.37 talks about gifts to employee. And remember when we talked about module 1, competency 2, that manpower management, we had that $10 per person limit for a subordinate to donate towards a superior's gift. There's a $10 limitation. So although it's not listed here, you can see how this information overlaps with the information in module 1.2. Page 38 talks a little bit about the penalties for committing an ADA violation, Anti-deficiency Act, for violating any of those purpose, time, and amount laws, the augmentation laws. So there are two types. You have an administrative penalty and criminal penalty, or a combination of both. So administrative, okay, you're continuously making mistakes, your supervisor have counseled you, you've been retrained, then you may be administratively penalized, meaning you are then removed from that position, that job, when circumstances warrant. So without any additional pay for that removal. Criminal, if you can show that there were criminal intent to defraud, to steal, to utilize resources for your own purposes, then you can have up to $5,000 fine, 2-year imprisonment, or both. Now, if there's additional charges pending based on what your criminal act was, know that it can go beyond 2 years. But just for basic criminal, it's the 2-year imprisonment, $5,000 fine, or both. All right, now look at some of the ADA reporting requirements. What are required of us if we identify an ADA violation? We've noticed that after reviewing our records that someone erroneously paid a charge, and we identify that it falls under the ADA violation for purpose, time, or amount. Well, there's some reporting requirements listed on 3.1.39. So it talks about, if you read through that paragraph, which is covered in FMR volume 14, it says that if you identify an ADA violation, you have 14 days from the date of the act to report that ADA violation. And further down, it says a preliminary review should be completed within 14 weeks from the date of initial discovery. So there are some timelines. And if you notice, a lot of the reporting, even when we talked about equal opportunity, equal employment opportunity, EEO, there were also some timelines associated with when we need to report to avoid any further issues. So remember that initial report, 10 days, preliminary workup within 14 days. And you can read through the rest of the bullets, descriptions. ADA relief. Let's see what it says here. 3.1.40. So in light of the explicit provisions of 31 U.S. Code 1351, it has been held that there is no private right of legal for declaratory, mandatory, or injunctive relief under the ADA. So in Thurston versus United States, the court declared that the statutes did not provide for any grounds upon which an individual found culpable of an ADA could seek relief from the court. So you can't seek relief from the courts if you conduct an ADA violation. And remember, even if you made a mistake and it's an ADA violation, it's still such. So we can't say, well, I made a mistake. So that's why we have a lot of separation of duties and a lot of checks and balances before we make an actual payment, because ignorance is not an excuse for making a mistake. So it's very difficult for us in our financial management realm to make errors in payment. We can make errors with budget side, resource management, because you can always go back and make another transaction to fix that transaction. But when it comes to actually dispersing those funds in fiscal law, once you make that payment, then you can still be held liable under the ADA relief, even if you get the funding back. All right, so on page 3.1.42, so now we have the appropriations. We looked at the laws associated with managing them, and then we want to look at what's the criteria, what's the rule for obligating. Obligating also means we're keeping our checkbook up to date. How much funding we have, what are our expenses, what have we obligated. And once you obligate the government funds, you have to pay that bill. So obligation typically comes once you sign a contract. Contract is complete, you've obligated the government. Or some instances, once you accept the item, like when you go to lunch, you go to eat. You look at your food before you even touch it. You see something doesn't look right, you say, I don't want it. You're not obligated. Once you take that food and you've consumed, especially if you've consumed half of that plate, you can't then say, oh, I ate half of it, but it still don't taste good. I want my money back, or I want you to deduct it from my check. You've already consumed the majority of the item, so most restaurants will say, no, you can't. So its best thing is to test your food out when you first get it and then let them know. So that's just an example. But criteria for recording obligations, the idea is to record promptly the principles on page 43, because our obligations are legally bound, and like managing your own checkbook is, if you don't annotate what you're spending or obligate those funds in the funding system right away, then you might think you have funds that are really not there. So the way how most of our processes work, we can't get around that, because you have to commit the funds, and then the commitment sits out there, we can see it, and then at some point those funds are then obligated. So the commitment sets the money aside so that we don't end up spending the rest of our money by the time the contract is awarded. So recording promptly, try not to over record or overestimate. So like for instance, when you do your DTS, Defense Travel System, you try to schedule your travel. That's typically an estimate of what you think it's going to cost. So that's the reason why we say 5 days after you come back to settle, because what you're doing is you're holding up those additional funds that you may or may not need if you settle your voucher. So once you settle your voucher, then those remaining funds can go back to the overall accountability of that organization. Now let's look at page 3.1.44, which touches a little bit on the continuing resolution. Continuing resolution is that temporary appropriation law that's put into place, like usually at the end of September, to cover us for 1 October and therefore usually October to December, because again, the law says we have to have an appropriation law. When the fiscal year starts, we have to have current fiscal year money. And so if we don't have, let's say, come 1 October of this year, it's going ready to start fiscal year 18. And if we don't have new funding appropriated for FY18, there's typically will be a continuing resolution. If they don't put the continuing resolution into place, then everything has to stop and shut down until we either have an appropriation act or a continuing resolution. So continuing resolution or temporary appropriation to get that stopgap to hold place to make sure we don't shut down in the meantime. So the restrictions with these continuing resolution is we cannot spend more than we spent for the same time frame last year, the prior year. And also, once you get the actual appropriation, you have to deduct what you've spent up to that point. So the way how this works out. So continuing resolution, current rate of operation refers to a sum of money rather than a program level. Current rate is amount originally appropriated, and concept of annualization. You're looking at the whole fiscal year when you're making your calculation. So rate of operations on page 46, rate not exceeding the current rate. Again, you're looking back at prior year and make sure that you're spending, it's minimal spending. All right, let's look at page 3.1.47, some more on the continuing resolution when current rate exceeds the final appropriation. So what that is saying is we are operating like we've been operating on CRs, continuing resolution, first quarter, second quarter. So what this is saying is by the time you get an actual appropriation, funding is approved, and you get less than what you've already spent up to that point. So you're going to need additional funding. So what it says on 47, if you obligate at the current rate and the Congress finally appropriates at a lesser rate, have you committed an ADA violation? And the answer is no, because you are operating under your legal rights and your budget authority for the CR, which says no more than what you spent last year. So even if they come back and then they appropriate less, you still have not committed an ADA violation. I remember another rule if on the last paragraph of 47 where it talks about no new starts. So it can't be a new idea, new project. We got to push that off until we get actual funding. So new starts, project activities. 48 again goes into our responsibility as accountable officials. So it gives a definition of an accountable official or individual is any government officer or employee who by reason of his or her job is responsible for custody of government funds. So I'm accountable for the funds that I spent. Further down, you see the definition for a collecting officer is a government official who receives or collects funds for the government. And that can be like your finance offices typically used to receive funding if a soldier or an individual loses a gear, whether their helmet, their backpack, rucksack. If they lost that item, they had to go to the finance office to do a cash collection voucher and pay the cost for that item. So collecting officer is that individual collecting the money from that soldier or that individual. And you can read through page 49, some illegal or improper payments, and the top there, and then reporting requirements. So factors, read that slide on the one that says reporting requirements on page 3.1.49. Factors that do not affect the duty, our duty to report. A mistake. I made a mistake. Inadvertently, I put an extra zero. Lack of intent. Even though I didn't have any intention to defraud the government, I didn't have any intention to do anything wrong, that's not an excuse. So we still have to report. So difficult working conditions, they don't like me, I don't like them, I made a mistake because I was upset, we cannot utilize. So when you deal with money and funding, limited resources, we are held to a higher standard. Pretty much you could say zero tolerance for making any errors. So that's why you need different individuals reviewing the same transaction. Best thing to do on page 3.1.50 is before you make a final decision to make a payment transaction, you can get advanced decisions, whether it's from the department accountable official, the certifying officer, or the dispersing officer. These are the ones actually dispersing the money. So we have the statutory right to seek an advanced decision from the DOD General Counsel. So you get get your lawyers involved and ask the question. Get it in writing. Again, if you don't have it in writing and you said, well, they told me I could do it, that typically does not slide. So ensure that you can get advanced decision if you don't feel comfortable signing off and making that payment. Next on page 3.1.51, relief of accountable individuals. So I've been held accountable because I made a mistake, but not even though it wasn't intentional. I can be relieved or not relieved. So there's some, let's look through this on page 51. Unlike the absence, so relief of accountable individuals, unlike the absence of a relief mechanism for committing an ADA violation due to an erroneous fiduciary, remember F before pecuniary, so fiduciary is, we could typically get relief because always saying purpose, time, and amount, we're verifying. But when you actually have to touch the funds, you are the one that pressed that button to make that payment, you cannot be relieved like that. So it says, unlike the absence of a relief mechanism for committing an ADA violation due to an erroneous fiduciary certification, and it says 31 U.S. Code 3527 and 3528 provides a mechanism for granting relief to a certifying officer or dispersing officer for an illegal, improper, or incorrect payment or a physical loss. And remember, because I have worked as a dispersing officer, and even if my soldiers lost funding or accountability of funds, it all falls back under me as the dispersing officer. So we need to ensure that individuals are trained and the proper procedures are followed and checks are being conducted. So on 51, you have physical loss versus just making an illegal, incorrect, or improper payment. So under physical loss, it says the Secretary of Defense determines that the official was carrying out official duties when the loss occurred. The loss was not the result of an illegal, improper, or incorrect payment. So these are instances where the GAO, Comptroller General, must grant relief under the following condition. So if it's clear that the loss was not the result of anything illegal, I should be relieved. The loss was not the result of a fault or negligence of the official. It just happened. Illegal, incorrect, or improper payment. Payment was not the result of bad faith or lack of reasonable care. The certification of payment was based on official records. So based on the information, official records that we had, the payment was made lawfully. You might find out later that, oh, that soldier was not even authorized BAH because they're really divorced. But if we have a marriage certificate in their records, then to us, they're still authorized. So if everything that we have says that they're authorized a payment and we make the payment, then we will be relieved from accountability. All right, so let's talk about statute of limitations. You know, when the criminal side, we always statute of limitation. How long do I have for them to do a review? So page 3.1.52 talks about the statute of limitation at the top. So if it's just a simple error, 3 years from the time the Comptroller General receives the. But if it's determined that it was fraud, there's no time limit on fraud. So you could have left the job 10 years ago and they can still go back, do an investigation and lead back to that 10 years of when you were there, someone call you, asking you questions about it. So repeating the basic axiom of fiscal law on 52, all that is saying is we can only expend the funds, obligate funds according to what Congress says we can do with them. So this is unlike Army standards or military standards. We usually say if it's not listed in the standards, then that means I can do it. The opposite occurs here. It's saying unless I can see it in writing and justify that what I'm doing has a direct relationship with what's listed, then I cannot spend those funds. So I think that ends the fiscal law, but you can look through page 53, gives you all the definition. 54 has some more. And let me point out the second to last one that says 41 U.S. Code 6301. I have heard some of individual mention that particular one on their exam, the Feed and Forage Act. And if you read through that on the bottom of 54, the Feed and Forage Act, this particular one authorizes the Department of Defense to spend more than they have available if they're deployed, and it deals with life, health, or safety. So let's say a storm came and blew down all our tents, and we didn't have enough funding, but we can spend more. So kind of like on credit, for lack of a better word, is the Department of Defense utilizing the Feed and Forage. So if you read through it, it says the Department of Defense can incur in excess of available appropriations in procuring, furnishing, clothing. So make sure you read through that and remember the Feed and Forage Act, because I've heard a few people say that they've seen that on their test. And over on page 3.1.55, let me draw your attention to the outlay versus output. And we talked about outlay already, meaning the issuance of a check, issuance or disbursement of cash. When the funding is getting ready to be taken out, the treasury have been taken out, that's an outlay. And then the output is based on my input, I get a certain output. So people have gotten confused with the output versus the outlay. So make sure you look at every one of these definitions, because they are all covered in this, between module 1 and this part of module 3. On page 56, another popular term I'm sure you've heard with the budget is sequestration. So that's the top of page 56. Sequestration is the reduction or cancellation of new budget authority, meaning we received the funding for XYZ, but it was sequestration says that once I got the funding, so this is usually at the OMB president level, is they can then, depending within certain guidelines, they can sequestrate, reduce, or cancel certain appropriations. Because remember, when we submit the budget request, it's typically almost 2 years earlier than when you actually need it that we start compiling those estimates. So by the time you actually get the funding, you as the head of the agency may determine that, yes, this was valid when I initially submitted my budget estimate submission, but now that it's actually fiscal year that I need the funds, that requirement no longer exists. The last one I'm going to talk about on page 56 is the Treasury warrant. If you remember, funding flow means after Congress appropriates the money, 2 things happen. 1, OMB apportions the fund to the agencies. The second thing, which is the first legal step, is based on the law. Remember, Article 1, Section 9 says no money can come out the Treasury until I get the appropriation law. So once Congress appropriates the money, the second thing that happens, Treasury issues a Treasury warrant. And all that is a notice to the organizations, the agencies, that their account has been set up based on what the appropriation law says. So this concludes CDFM Module 3, Competency 1, which is fiscal law. You will need to review the fiscal law before you take the Module 1 or the Module 2 exam. So even though fiscal law is covered in Module 3, the requirement for 1 and 2 is to also know fiscal law. So I hope this was very helpful for you, and I'll see you next time.